A lot of times throughout workers' compensation claim, your doctor at some point may say that, hey, you need some treatment such as a surgery, an injection, whatever it is, but that the major contributing cause is not this work accident. Essentially, what he's telling you is that you need this, but it's not from the work accident. A lot of our clients have questions, and rightfully so, is, well, how can you treat me this long? And now all of a sudden you're saying I need a surgery, but it's not related. What do you do in that instance? Well, that's why it's important to have an attorney, because as an attorney, what we would do is first, we would get what's called an independent medical evaluator, where you would go to this doctor. He would look at your past medical records, he would evaluate you, and then he would make a determination of whether or not this condition, this procedure being recommended, is the work accident. After we get that opinion, then what we'll do is we'll go to a judge and have him appoint what's called an expert medical advisor. So essentially, what happens is when you have two competing doctors, in the sense that one doctor is saying it's not related, one doctor is saying it is related, you can go ask the judge for an EMA or expert medical advisor. Usually, this is a third tiebreaker doctor where you would go see him, he would review your records, and then he would make the recommendation and opinion that it is either related or not related. Well, then what happens? Usually that's it. Usually, once you have the expert medical advisor's opinion, the parties go by it. Now, that's not always the case. We most recently had a trial where we had a client, his authorized doctor was recommended a very intrusive cervical fusion surgery. The insurance company got an independent medical evaluator to say it's not related. We went in front of the judge. The judge appointed an expert medical advisor. That doctor came back and said it was related. He needed the surgery. Again, typically it would end there. The insurance company chose to fight this. We went to trial. We were victorious at trial. The judge agreed with us that this is related to the work accident. This claimant needs this surgery due to the work accident. Again, you would think it would end there, but did not. The insurance carrier did not agree with the judge, which is their right, and chose to take it to the First District Court of Appeal and appeal his order. The First District Court of Appeal heard the case and again agreed with us and ordered the insurance company to set up the cervical fusion surgery and pay for it. This is one of the many reasons it's extremely important to have an attorney. These intricacies of the medical opinions, doctors working for the insurance company, and not knowing what your rights are if a doctor comes back and says, hey, this isn't related. A lot of people, and to no fault of their own, think that's the end of it. Well, if the doctor's saying related, it's not. Clearly, there's many more options you have. We can get in front of a judge, we can win, and we can make sure you get the treatment you deserve.